France's top appeals court ruled Wednesday that Felicien Kabuga should be transferred to a UN tribunal in Arusha, Tanzania, to stand trial on charges of genocide and crimes against humanity. Kabuga, arrested near Paris in May after 25 years on the run, asked to be tried in France. But the Court of Cassation upheld the decision of the lower court of June 3rd, ruling that there was no legal or medical obstacle to implementing an international warrant for Kabuga's transfer to the Arusha-based tribunal. Kabuga Felicien, 87, is considered a sponsor of the genocide against the Tutsi. He allegedly bankrolled the genocide and imported machetes used by the Interahamwe militia to exterminate the Tutsi during the genocide. Online with me is Dr. Alphonse Mulefu, a legal expert and law scholar, and he will discuss about this further. Good evening, Doctor.
Good evening.
Now, of course, the court in France ruling to extradite Felicien Kabuga to the UN mechanism. How is this a step closer to justice?
Since he got arrested, this was the only expected outcome because France has an international obligation to cooperate with the international residual mechanism. But it is indeed true to say that we are finally getting closer to seeing justice done. His initial indictment was issued in 1997, so the over 20 years search for Kabuga is finally over. So immediately after he is delivered at the Arusha branch of the mechanism, he will be brought before a judge to ensure that his rights are respected and the decision will be made on his provisional detention. So we can finally see the actual trial starting.
In your recent publication, you argued that Kabuga should be tried in Rwanda. What does his transfer to Arusha, to the Arusha-based mechanism, mean? And doesn't that bring him closer to home where he committed the alleged crimes?
Well, bringing him to Arusha instead of, for example, taking him to The Hague, as the mechanism prosecutor had requested before, is certainly a better thing. But it is not enough because the mechanism's rules of procedure and evidence allows the mechanism to perform its functions away from the seat of the mechanism, if authorized by the president of the mechanism in the interest of justice. So this is at least an opportunity that is going to be lost by the mechanism. Otherwise, they should have taken this opportunity to consider the interest of victims and the interest of the concerned people by bringing him, maybe even if he might not be tried by the Rwandan courts, but be tried on the soil of Rwanda using Rwandan facilities. Because the reasons as to why ICTR was based in Arusha no longer exist.
Some people may think that his elderly age or other health could be a hindrance to justice. What do you make of this?
Well, I have heard some people make such a statement, but this year someone called Bruno Day, a 93-year-old former Nazi guard, was convicted of his role in the Holocaust. In 2016, Hanning, a 94-year-old, another former SS guard, was pushed in a wheelchair for trial. And the crimes they are accused of happened 75 years ago. So Kabuga is 85. He claimed that he's much older than that. He is accused of crimes that occurred in 1994, just 26 years ago. The reason these crimes do not have time limitation is that they are too heinous to forgive. So I don't think that the tribunal or the mechanism as it is today will be in position to entertain such a claim.
Many thanks indeed, Dr. Alphonse Mulefu, for your insights about this.
Thank you very much.
Well, that was Dr. Mulefu Alphonse, a legal expert and law scholar, speaking to us about the decision to extradite Felicien Kabuga to the UN mechanism.